Good afternoon. I'd like to welcome everybody here this afternoon. My name is Terry Dennis. I will be chairing the meeting this afternoon. With us today we have Ms. Erica Ritchie, Mr. Nathaniel Teed, Todd Gowdy, Gary Grewell, Travis Kiesig, and I do believe that's it right now. Before we get started, today's business, I'd like to table the following document. IAJ 14-29, Ministry of Government Relations, responses to the questions raised at the November 28th, 2023 meeting. Today, our committee is also tabling a list from the Law Clerk and Parliamentary Council of the regulations and bylaws filed with the Legislative Assembly between January 1st, 2023 and December 31st, 2023, which have been committed to the committee for review in person to Rule 147.1. The Law Clerk and Parliamentary Council will assist the committee in its review by submitting a subsequent report at a later date identifying any regulations that are not in order with the provisions of Rule 147.2. However, the committee may also decide to review any of its regulations or bylaws for policy implications. I am also tabling 3 reports from the Law Clerk and Parliamentary Council that identify any issues pursuant to 147.2 that he found with regulations and bylaws filed in 2017, 2018, 2019, and any steps that have been taken to rectify these issues. If the committee chooses, it may bring in the Law Clerk and Parliamentary Council to review these reports at a subsequent meeting. IAJ 15-29, Law Clerk and Parliamentary Council 2022 regulations file. IAJ 16-29, Law Clerk and Parliamentary Council's 2021 bylaws filed. IAJ 17-29, Law Clerk and Parliamentary Council 2017 report on regulations and bylaws. IAJ 18-29, Law Clerk and Parliamentary Council 2018 reports on regulation and bylaws. And IAJ 19-29, Law Clerk and Parliamentary Council 2019 report on regulations and bylaws. With that, we'll move on to consideration of bills. Today, we will be considering 7 bills, 1 with Minister McMorris, 1 with Minister Merriman, and 5 with Minister Eyre. We will recess from 4:30 till 6:30. First, we will consider Bill 153, the Miscellaneous Municipal Statutes Amendment Act 2023. Minister McMorris is here with his officials. I will remind the officials to identify themselves and record for the record before they speak, and do not touch the microphones. Hansard operator will turn them on for you. We will begin with our consideration with Clause 1, short title. Minister McMorris, please make your opening comments and introduce your officials.
Thank you for that, and I'll make sure I don't touch the mic. I almost did and would have blown this whole committee meeting apart. But anyway, thank you very much. And I will let the officials, as they speak, if they answer any questions, to introduce themselves, because I've got some at the table and some at the table behind me. So today we are considering Bill number 153, which proposes changes to the 3 municipal acts. The 3 acts that govern municipalities in Saskatchewan are the Cities Act, the Municipalities Act, and the Northern Municipalities Act 2010. These 3 municipal acts create the framework for how municipalities are established and function. These proposed amendments are limited in scope. The changes improve key areas related to assessment appeal, organized hamlets, and other minor process adjustments. I want to highlight a few of these key areas for you. The first is improvements to the property assessment appeal process. In recent years, the ministry has updated the regulations to improve the system. Now we are updating or adjusting wording in the Act to better reflect the changes. Another key policy area is organized hamlets. Regulatory amendments to clarify the roles of an organized hamlets board and the rural municipality were approved in the summer of 2023. As part of the review, some changes were identified for the Act. The most important was to require an agreement between the organized hamlet and the rural municipality on things that are a shared or delegated responsibility. Virtual meetings have become more commonplace. Proposed changes will establish clearer rules for holding virtual council meetings and ensuring the public continues to have a place to view the meetings. These changes will also provide all municipalities the authority to phase in property taxes, whether increase or decrease. Extending this property tax tool to all municipalities will allow them to manage tax shifts that may occur due to reevaluation of properties. Currently, only cities have this authority. Some of the proposed amendments are in the Municipal Act only, such as those related to organized hamlets. Others are in all three municipal acts to ensure consistency in all three acts. With that, I would be happy to answer any questions that the committee may have.
Thank you, Minister. We'll now open it up for questions. Ms. Ritchie.
Thank you, Mr. Chair. I want to start by asking some questions, starting with the amendments to Section 68, the Organized Hamlet Agreement, and the 68.1 subsection 1, where the amendments call for a hamlet board and a rural municipality to enter into an agreement in accordance with the regulations. And then it goes on further to indicate that such an agreement must be signed by the rural municipality and the hamlet board. And there's some time stipulations around that. And so I guess maybe my first question is, you make the amendments make reference to the regulations. Are those regulations already in existence, or are they something that is contemplated in the future?
I'll maybe just turn it over to Andrea to my right to go through this.
Thank you, Minister. Andrea Ulrich, Director of Legislation and Regulations at Government Relations. The municipalities regulations is where the details of the agreement would be. Those details are not there yet because we needed to put the authority in the Act first. But it is something that we've been consulting with stakeholders, with organized hamlets and RMs for a few years now. And we're currently actually consulting on proposed wording for those regulations, but yeah, they do not exist yet.
And thank you for that response. I wonder if you could please tell me what is being contemplated for the content of those regulations.
Yes, I can speak a little bit to it. Of course, nothing's been approved. We're still in the consultation stage, as I mentioned. One of the items is a communication protocol between the Hamlet Board and the municipality. From the consultations we've done, from speaking with organized hamlets and RMs, when there's disagreements or disputes, one of the problems often is lack of communication or lack of consistency of that communication, or one side feeling misunderstood by the other. Fairly common kinds of problems. And so if one part of the agreement we were proposing is that they would establish a communication protocol. So how they would communicate about certain things like budget, like having joint meetings, that sort of thing. But it would be not something we would prescribe and tell them how to do, something they would agree on. A few other things are areas where it's not quite as clear who decides. If there's a percentage of levies or taxes or a different mill rate in the organized hamlet, just having those things for clarity in the agreement. And then there's some areas where the RM can delegate certain functions to the hamlet board, such as asset management, facility management, even project management. So if they were doing things like that, having that in the agreement for clarity.
And it was mentioned that there's been some consultations occurring on these amendments. Can you please tell me how many RMs and organized hamlets were consulted? And in particular, perhaps, if you could tell me if the RM of Wilton was consulted or the organized hamlet of Lone Rock?
I can check. We mostly work through the associations, and so we work through parks, which represents a number of organized hamlets. That's the, Provincial Association of Recreational Communities of Saskatchewan. And we did do some specific focus groups back in 2021, and I don't believe either of those parties were there. There may have been some submissions through the associations from either of those parties, but I wouldn't know specifically.
And how would they have been notified of this opportunity to provide feedback? Was there notification sent to all RMs?
It would have been through parks and through municipalities today, the newsletter that goes to all administrators. So yeah, the RM of Wilton would have received that along with other RMs.
Okay. Well, it's maybe a little bit ironic, but perhaps with the lack of a communication protocol that may not have gotten to all the interested parties. I guess just sort of delving a little bit deeper into what may be the subject of those regulations. I understand that there are some concerns with access to RM council records in general, and will by organized hamlets who will be sort of the affected by these changes. So will the regulations contemplate how RM decision items, bylaw changes, and anything else affecting the organized hamlet is communicated, and in what form?
Yes, there are currently regulations regarding matters like that were approved and since I believe it was August 2023. And so it regards policies of what information needs to be available to the public, both by the Hamlet Board and by the rural municipality. So those come under documents for public inspection, and also requiring Hamlet boards to have a certain policies in place regarding how they function as a board, and the RM to have certain policies in place in terms of their requirements and processes for approving the budget, for example. So those are very new changes that have just come into effect and will be operational by summer of 2024 when the AGMs, organized hamlets, are having annual general meetings. That's when they're required to have those policies in place.
And are there any penalties for an RM refusing or not meeting those requirements? Are those in the new regulations?
They would be treated like any other document that is required to be available for public inspection. So if they're not doing that, it's a matter of public accountability. So that's something that the public could point out. I'm trying to access this; it's not available, right? That's with over 700 municipalities. It's not something we can possibly manage, but as many things that RMs are required to do, it's there, it's in the Act, and in this case, the regulations, and their citizens can hold them accountable.
I'm not sure that fully addresses the concern. There have been cases in the past where there has been a failure on the part of RMs to provide information as per Section 117. And what I'm looking to establish is whether or not the changes that are reflected in these amendments before us and the corresponding regulations are going to in any way hold RMs accountable in a timely fashion to provide information that's requested and duly by rights should be shared by municipalities with their organized hamlets.
Certainly, and that's one of the issues we heard about when we were consulting and when we were looking into some of the issues around organized hamlets is the communication and information. So yeah, that's certainly something we've attempted to provide clarity on, and as I said, it's very new, so we haven't received a lot of feedback yet on how that's working. Also, the Office of the Information and Privacy Commissioner is certainly a good place for people to go if they feel that they can't access the information that they should be able to access.
Well, I guess there's always that. It does sometimes become cost prohibitive, though, if fees are then applied for accessing documents that should be readily available. I notice in that section, it does identify that, a lot of this information could be made available on a website and not require going to those sorts of extents in order to access information that should be available to the public, and especially as it relates to organized hamlets, something that deeply affects their interests, particularly in cases where RMs have an interest in changing the manner in which they are part of that RM in terms of dissolution, in the case in particular for Lone Rock. But I guess I just want to go back and ask the question again, like, are penalties contemplated when an RM refuses to provide information as per Section 117?
One last resort is there's fines and penalties. So anyone that contravenes the act can be brought the court system, and then it could be enforced that way.
And if that route is taken, what would be the process that they would need to follow?
I'm not familiar with bringing a case to the courts.
Would another official be able to respond?
I'm sorry. Thanks. Rod Nazowicz, Executive Director of Policy and Program Services. Yeah, there are general offense and penalty provisions in the Act that provide for any violation of the Act to be fined for an individual. And there's continuing fines, there's lump sum fines, but it has to go through a court. And one would have to make an application through the provincial courts about exactly what the contravention is, and show up, and then the court decides on those fines and penalties and who is creating the offense, and levy those against a municipality or an administrator. I mean, those things are required in the Act, so it's the duties of an administrator to follow to make sure that stuff is available for public inspection and for council as well.
Thank you for that response. It's also, there's been some changes in terms of the manner in which disputes between hamlets, hamlet board and a council are resolved. I see in section 77, subsection 1, there is a number that are listed that that can go forward. Is it the case that does the ongoing dispute between the arm of Wilton and the organized hamlet of Lone Rock fall under any of the categories that are provided in that section?
I think I'll start by answering that in, you're being very specific on an organized hamlet, Lone Rock, and the arm of Wilton, and we probably aren't going to get into the particulars. This is an overarching legislation that affects all organized hamlets, and the intent of the overarching legislation is to avoid disputes between organized hamlets and rural municipalities. I think it's fair to say that not all maybe RMs understand their responsibility to the OH, and not all OHs understand the responsibility towards the RM. On the Lone Rock Wilton piece, it's a lot of their dispute is in front of the municipal board. It's probably not appropriate for us to start singling them out and what is or what isn't appropriate. We'll kind of answer to general questions regarding organized hamlets and municipalities.
So in that case, hypothetically speaking, if, say, a organized hamlet has an existing dispute before the municipal board, and now we have these regulations coming into effect where, you know, it requires an agreement as it's laid out in Section 68. How would a case that's currently before the municipal board be impacted by these changes?
So when these changes come into effect and they're required to have an agreement, then existing organized hamlets and RMs will have to also establish that agreement. And it's defined that failure to come to an agreement is also a dispute. And so their current dispute is already before the SMB, the Saskatchewan Municipal Board. And if that is not resolved at the time this comes into effect, then there could be potentially more items. But I'm not sure that would really be within the purview of the Saskatchewan Municipal Board on how to deal with the current case versus what might happen in the future.
In reviewing the latest annual report for the SMB, that being 2022, they've set out targets for, I guess, service targets. But I didn't see anything there in terms of sort of what would be a reasonable time frame in which a dispute in particular, such as, one occurring between a organized hamlet and an RM, should be resolved within. Can you please tell me if those kinds of targets exist, and if so, what they would be?
Answer. But before she answers it, I'll just say that the municipal board, Bill has nothing to do with the municipal board. We're going to try and keep it on what this bill pertains to. But it's hard to not use the expertise that we have in the room because they can answer all your questions. So, we'll certainly take a crack at that one, and then we're going to try and bring it back to just Bill specific, please.
Yeah, I would caution that we stay on track to what's in front of us as far as the bills, and not get into confidentiality in a specific case.
Bonnie Chambers, Executive Director of the Advisory Services Municipal Relations Branch in Government Relations. Our understanding with the delay at the municipal board and that this hasn't happened is because of changes to legal counsel on one side or the other. As that is a separate entity of government in arm's length, we're not aware of or privy to when the hearings will be held. What we do know is that there was changes to legal counsel, and the SMB gave time for the legal counsel to be brought up to speed on the matter. And that's as far as our understanding is.
Thank you for that response. Do these amendments to the municipal statutes contemplate having either within the Act or the regulations stipulated timeframes in which disputes will be resolved?
No, that would not be contemplated in this. I mean, you can imagine the number of different disputes that come before the SMB. Some can be handled quickly. Others take quite a bit of research and time. And so, no, we're not. The SMB arm's length would not be appropriate to put timeframes in an act like this.
And as part of the consultations that occurred in lead up to these amendments, was it considered to include anything further with respect to either ensuring that conflicts of interest, real or perceived, are avoided by RM councillors?
There are no conflict of interest related amendments pertaining to RM councillors. As part of the organized hamlet consultations, we did look at conflict of interest for hamlet board members, and those are in the regulations that were approved in summer 2023.
Could you please share with us what those were?
Just very similar to municipal council members. If there's a conflict of interest, they step away, they declare what it is, and they remove themselves from deliberations.
So in terms of conflicts of interest, do the regulations include anything with respect to political donations?
Nothing that's specific.
Nothing that specific. Okay. sort of not related to that line of questioning, but it's also my understanding that before services can be dismantled within an organized hamlet, the RM needs to receive approval from the SMB before performing those works. Is there anything in these amendments that would address situations where such approvals have not been received?
No, there isn't.
No, there isn't. Okay. So I just maybe going back to one of your earlier responses when you mentioned that Parks was consulted. It's not clear to me that all organized hamlets would be represented by Parks, because some would be, resort villages and some would not. And so what attempts or efforts were made to consult with OHs that are outside of that sector?
Yeah, that's correct. Not all organized hamlets would be part of Parks. We also worked with SARM in terms of so for them to communicate to their members. So that covers all of the RMs that have organized hamlets, and what we would like to see. This is what we just can't consult with every single municipality. Numbers wise, it's impossible, of course. But we do our best to work with the associations, and they're very good at getting information out to their members. So we did have a number of touch points over the last several years with SARM on this. And we also communicate through municipalities today, which goes to administrators. So there is an expectation and responsibility that administrators of RMs who that have organized hamlets will be passing on that information.
But just to be clear, in those consultations, you did not receive any feedback regarding issues or concerns with lack of SMB approvals with respect to dismantling of services within organized hamlets?
No, we did not hear about that.
Okay. Or did you hear any issues about information being provided to organized hamlets on the issue of council elections or by-elections? Did that issue come up at all?
No, I don't believe so. We definitely heard a lot about organized hamlet board elections and some clarification about who can vote in those. The manner of voting, it used to be just show of hands. We've now made it more flexible so that they can use a ballot. They can continue to use show of hands if they want. They can have nominations, but really because we are now treating them more like a board. As a board, they're going to have policies around their elections and how they are held. So all of the talk we heard about elections during consultations were about the Hamlet board member elections.
But you didn't hear any concerns regarding how there was obstruction of information being shared between RMs and organized hamlets with respect to upcoming elections?
I don't recall anything like that.
Okay. Okay.
Sorry, Ms. Ritchie, if you could please stay on task of Bill 153, please.
Yes.
Questions pertaining to Bill 153.
Okay, thank you, Mr. Chair. I'm just trying to understand, as part of the consultations for the amendments that came forward, the feedback that was received and then contributed to the amendments that we see before us, because certainly in my own engagement with stakeholders, these were some of the matters that were identified, issues around timeliness, information sharing. Good to hear that, that there's going to be some communication protocols, and some of the things I'm mentioning might be things that you might want to consider as you build those out. I think related to that has been the issue of decisions for the establishment of corporations by RMs. It's my understanding that before an RM can establish a corporation, it has to obviously, go before the RM, be approved and signed off, and then publicly shared. Are the amendments that I see before me, is there anything here, either here or in the regulations, that address issues where, in the manner in which that needs to be undertaken?
No, that
No.
has nothing to do with this act.
Okay. I guess then lastly, sort of along this line of questioning, I've also, another issue that's come to my attention is the cost for insurance of residents within organized hamlets for fire protection, and also the protection of water pipes and things of that nature. Will the regulations that will be part of the amendment process be addressing insurance provisions for these ratepayers? No?
It's not really part
No?
of this either, no.
Okay. I wonder if you could tell me what feedback you received that suggested organized hamlets should get a shorter period of inactivity before they're demoted?
Yes. So one of the concerns we heard is that 2 years is a very long time, and especially when there's annual requirements for organized hamlet boards. So once that organized hamlet is no longer serving its function, is no longer engaging in its legislated activities, then the RM would request that that their status be revoked or disestablished. But that's a request to the minister. So it's not an automatic reversion either. It's a request to the minister.
Back to sort of some of the changes to Section 77. I'm wondering if you could explain to me why it was necessary to itemize the types of disputes that are listed in subsection 2. What has been gained by taking this approach?
Certainly. So we, of course, consult with this SMB when we have amendments concerning their role. And as part of that discussion, it was recognized that the matters for disputes should be pertaining to matters within the Municipalities Act and the municipalities regulations. So matters that are legislated, and that is the clear role where the SMB has the expertise and is more appropriate for them to be ruling on. So the dispute that the matters under subsection 2 are things that would be in the agreement, and therefore it would be clearly laid out in the regulations in terms of what's supposed to be in the agreement. It would be clear, where that dispute lands, and there would be no question of whether that jurisdiction would fall under the SMB or not.
Okay, so that's a very helpful point you just made in terms of there would be sort of a clear relationship here between the items that are part of the agreement and then those things that would be identified as if there was a dispute, they could come before the board. So what about in the case of if an RM is contemplating sort of dissolution of an RM, would that be something that would be considered or contemplated under Section 77 or the sub 2?
Sorry, do you mean organized hamlet?
I mean organized. I'll try to restate it. Sorry if I misspoke. I'm talking about a case where if a rural municipality makes the decision to dissolve an organized hamlet, would that be a matter that would fall under the items listed in subsection 2?
No, it would not, because it would be the minister who would make that decision. Yeah, it's a request to the minister, so it would not be the RM making that decision, therefore it couldn't be a dispute.
Okay. Oh, so that's, I wasn't aware of that. So that's interesting. So before an RM can proceed with dissolution, they have to. And what section would that fall under?
So in the bill, section 52, where it makes that change from 2 years to 1 year, that's also where it has the wording that the council shall request the minister to order the reversion of the status of the organized hamlet if no active hamlet board has existed for the preceding year.
Okay, so I'm just looking at that section right now. And so is it correct, is my understanding correct in terms of the municipality? Maybe you could just put that in layman's terms for me, please.
So if the organized hamlet is not active, and active is now defined in regulations as having an annual general meeting as well as the policies that they're required to have, then the council of the RM could come to the ministry and say, this organized hamlet is not active. We're requesting that the minister order that its status be reverted, and then the minister would look at that and see if it's appropriate to make that order. And then just as an organized hamlet is established by a minister's order, then that status is also able to be taken away with a minister's order.
Okay, and so those would be the only circumstances under which that dissolution could go forward. Basically, it's that the organized hamlet hasn't sort of been managing their affairs, meeting as an organization. Would it have anything to do with any kind of financial considerations of the RM?
Under this provision, it's if they're not active, so if they're not meeting their responsibilities. There's always Section 399, and the minister has the authority to intervene. So if there are other situations where the minister decided to order an inspection and found something was remiss, could make any order that pertains to whatever that inspection found. So there's other circumstances where something could be changed, but under this section, in terms of the status of the organized hamlet, it's whether there's activity or not. In many of these places, population is declining. There's maybe 20 people left. There's several organized hamlets with very small populations, and so they simply don't have the resources or the will to carry out the requirements of having an organized hamlet board. So those would be the more common.
So if I understand you correctly, an RM cannot act unilaterally. They have to put the request to the minister.
In terms of the status of the organized hamlet, yes.
Okay. And then likewise, in order to proceed with dismantling waterworks, that too would need to, that would require minister approval or board approval, or both?
So because the services are the RM, whether those services are in the organized hamlet or not, it's still under the governance and authority of the RM. So in the future, something like that could be contained in an agreement, and that would certainly be a good practice so that there is clarity, especially when there could be impacts on an organized hamlet. But currently, that's not a requirement, and the RM has the ability and authority to act in what services they provide their residents.
Well, that's different than my understanding, so thank you for that correction. But again, just to make sure that I have this correctly, so you're saying that it's within the RM's authority to dismantle services, and they do not require approval from SMB before, and there's nothing in these amendments. Well, you are saying that in the future it could be part of the agreement, but as it presently sits, there is no approval required.
Correct.
Correct? Okay. All right. Thank you very much. So with the changes that we see to Section 77, how are you anticipating this to impact on the case work before the SMB?
That isn't the reason why we're doing this. I don't think we've done any work on that. That wouldn't be kind of what. This is just to make sure that organized hamlets and RMs are communicating better and have a better understanding of the responsibilities before there gets to be any dispute.
So in that case, hopefully it would reduce and limit the number that need to go for it, because these things would be more clearly outlined in an agreement?
I guess, yeah, I would say that hopefully that's the case.
Okay. And in the consultations that have occurred on these amendments, did you hear anything back from stakeholders regarding lengthy delays and how these amendments might be able to reduce them?
Specifically regarding disputes?
Yes.
We did send out a survey because we don't have information regarding disputes if they're using the three-person appeal board. And there was only the one. They're really not that common to have formal disputes. There were a couple of instances where they were heading that way and were able to come to a resolution, but they're really quite uncommon. So since the ability for them to be referred to the SMB, only the one has, the one you're referring to. But yeah, other than that, it's not common, and so we did not hear that from anyone else.
Has a consultation report been prepared that summarizes the feedback received?
There is a report that we published regarding the focus groups we did in 2021. And I believe that would be the only thing that has been published publicly.
I think probably it's common to, as Andrea mentioned, who we consult with. It's not common to do a report on every piece of information. We did on the focus groups, but it isn't common on other legislation.
And would it be possible to receive a summary of the feedback that was received?
Probably do a summary of what we heard from the focus groups from 3.5 years ago, 3 years ago, 2021.
Was that, but there were consultations that have happened since then, is that right? Yeah. Is there a record of that feedback that could be provided?
Said we can tell you who we talked to.
Okay.
I don't think we have a roll-up of what we had, a printed version of what we had heard.
Okay, thank you very much. I appreciate that. Perhaps maybe just to kind of round this out, in cases where there are disputes between hamlets and councils, as is sort of contemplated in section 77, subsections 1 and 2, will there still be an appeal process if one of the parties is not satisfied with the outcome?
A decision of the SMB can be appealed